The Clerk.
Government business, order of the day number 1. Migration Amendment, Duration of Detention Bill 2003, resumption of debate on second reading and on the amendment moved by the member for Lalor.
Order. The original question was that this bill be now read a second time. To this, the honourable member for Lalor has moved as an amendment that all words after that be omitted with a view to substituting other words. The question now is that the words proposed to be omitted stand part of the question. The member for Cunningham.
Thank you, Mr Deputy Speaker. The purpose of this bill is to amend the Migration Act 1958 to prevent or limit courts from issuing interim orders for the release of immigration detainees. The bill has been introduced to prevent interlocutory or interim orders for the release of detainees, whether or not in the context of broader judicial proceedings. Australia's refugee policy, or specific practices by the authorities, have been subject to harsh criticism by its domestic courts, legal, medical, church and human rights groups, parliamentary inquiries, international human rights organisations and United Nations bodies. Australia is in fact becoming an international pariah due to the actions of the Prime Minister and the government. As we have seen, in recent times this government has faced a raft of legal challenges under Australian law, and there is intense and ongoing legal scrutiny of its actions in regards to the treatment of asylum seekers. The government's reaction has been to further restrict the ability of the courts to make decisions to uphold human rights, or in any way limit the government's already far-reaching powers to repel or divert unwelcome asylum seekers. The government's border protection and mandatory detention policies have given rise to such human rights abuses as the incarceration of children in Australian detention centres and the shameful tamper and children overboard affairs. Previous speakers, such as the member for Lalor and the member for Grayndler, have highlighted the national disgrace of children in detention. Unfortunately, this is just one deplorable element of the government's detention regime. This bill is yet another example of the government's strident efforts to further broaden its power in this area and to deal with asylum seekers as criminals rather than on a more humane and compassionate basis, as was done in the past and as we should be done here and now. The Migration Amendment Duration of Detention Bill 2003 adds 4 new subsections to Section 196 of the Migration Act. As I said before, the purpose of this bill is to tighten mandatory detention rules to prevent courts from ordering the release of failed asylum seekers and those awaiting detention. In attempting to pass this bill, the government seeks to remove a loophole which allows a federal court to rule against the Immigration Department detaining people indefinitely. Remember that word, Mr Deputy Speaker, indefinitely. The Minister for Immigration and Multicultural Indigenous Affairs has made no secret of his irritation when the government's hardline stance on detention issues is questioned or undermined by the community, legal fraternity or the courts. In April of this year, the full bench of the federal court decided that a failed Palestinian asylum seeker was being detained illegally. 25-year-old detainee Akram al-Masri had sought release from detention because he wanted to return home, but his repatriation could not be arranged. The decision of the federal court had implications for dozens of others in detention fighting deportation. 20 people have since been released by court order. A bit of history is warranted here. In 1992, the Australian Parliament, under a federal Labor government, introduced mandatory detention via the Migration Reform Act. The Act commenced in 1994 and introduced mandatory detention of all so-called unlawful non-citizens. The Migration Reform Act included Section 196, which provides that an unlawful non-citizen must be kept in immigration detention until he or she is, and I quote, A, removed from Australia, or B, deported, or C, granted a visa. Subsection 196(3) specifically states, and I quote, to avoid doubt, subsection 1 prevents the release, even by a court, of an unlawful non-citizen from detention, other than for removal or deportation, unless the non-citizen has been granted a visa. The Minister argues that the intention of Section 196 was to make it clear that there was to be no discretion for any person or court to release from detention an unlawful non-citizen who is lawfully being held in immigration detention. In the Minister's second reading speech on this legislation, he stated, and I quote, "Mandatory detention remains an integral part of the government's unauthorised arrivals policy. The government needs to ensure, as a matter of public policy, that all unlawful non-citizens are detained until their status is clarified. This means that they must continue to be detained until one of three things happens: either they are removed or deported from Australia, or that they are granted a visa. It is not acceptable that any person who is or who is suspected of being an unlawful non-citizen is allowed out into the community until the question of their status is resolved." And that's in a nutshell, Mr Deputy Speaker. That summarises the harsh, often brutal detention regime which currently operates in Australia. The Greens have consistently opposed mandatory detention. This policy flies in the face of the way in which Australia traditionally dealt with refugees and immigrants, especially in the post-World War II period. I think we as a nation were proud of the compassion we showed to the many people who were displaced as a result of conflicts in Europe and Asia during the post-World War II period and leading up to the 1990s. In my own electorate of Cunningham, in the Illawarra, we had a substantial influx of refugees and immigrants, many of whom had none of the papers that the Minister told us are often destroyed by asylum seekers. After the war, these displaced people were housed in hostels within our communities. Their children went to our local schools. Many of them eventually found employment locally and have added substantially to the now rich multicultural society which exists in the Illawarra and throughout many regions of Australia. How things have changed, Mr Deputy Speaker, since 1994 and especially under the Howard Coalition government since 1996. Compassionate treatment of asylum seekers, who are now rather coldly termed illegal non-citizens, has gone out the window, and all the forces of the federal government, administrative and legal, are being railed against them. As the Minister outlined in his second reading speech, since 2002 the Federal Court has decided that the Migration Act does not prevent the Court from making interlocutory orders that a person be released from immigration detention pending the Court's final determination of the person's judicial review application. These orders mean that a person must be released into the community until the Court determines their application. This is quite a clear determination. Release from detention is the right and just thing to do in these circumstances. And it is comforting to know that the Court is able to step in at this point. It is obvious that the Department of Immigration and the private firms managing Australia's detention centres have had trouble in implementing a truly humane regime to deal with detainees. The Court's intervention is obviously needed, especially on humanitarian grounds. However, the Minister is unwilling to accept the Court's intervention here, as is the Government. The Government is unable to accept the independent umpire's decision. The Government refuses to listen to the many voices in the Australian community who deplore its action, supposedly in their name. The Minister has stated that the Court's final determination of the case can take anywhere between several weeks and several months, and as a consequence, and I quote, "where the person is subsequently unsuccessful in their visa application, that person must be relocated, redetained, and arrangements then made for their removal from Australia. This is a time-consuming and costly process and can further delay removal from Australia." End of quote. Is the Minister here giving as his excuse for indefinite detention the mere fact of administrative inconvenience? Well, frankly, this is not acceptable in a so-called civilised society. The Minister further states, and I quote, "I understand that there have now been some 20 persons released from immigration detention centres on the basis of interlocutory orders. In the case of more than half of these persons, removal action has been commenced as they are of significant character concern, and the Government believes their presence is a serious risk to the Australian community." End of quote. Using this kind of anecdotal evidence to justify a significant change in Australian law is unfortunately the standard of justification we have come to expect from this Government. More and more Australians every day are getting wise to the Government's lack of compassion and calling into question the limits to which our border protection policy has been taken. As I said before, this bill seeks to amend the Migration Act to make it clear that, unless a so-called unlawful non-citizen is removed from Australia, deported or granted a visa, the non-citizen must be kept in immigration detention. And this applies unless a court finally determines that the detention is unlawful or the person is not an unlawful non-citizen. In defence of this bill, the Minister has further stated, and I quote, that this bill ensures that an unlawful non-citizen must be kept in immigration detention pending determination of any substantive proceedings, whether or not there is a real likelihood of the person detained being removed from Australia or deported in the reasonably foreseeable future, or a decision to refuse to grant, to cancel or refuse to reinstate a visa may be determined to be unlawful by a court." End of quote. This government's record in regards to the treatment of asylum seekers, as I and many other speakers have said in this debate, is nothing short of shameful. The absolute lack of compassion and a willingness to use people seeking asylum as political pawns has come to characterise this government's detention regime as excessively harsh and regressive. As a consequence, the reputation of this nation has been tainted. On top of this, it appears that the government's proposal in this legislation may well be contrary to and fly in the face of established Australian legal precedent. The government insists that its detention policies, such as the one we are considering here today, are not designed to be punitive. Not punitive, I ask? The High Court in Che Kang Lim versus the Minister for Immigration, Local Government and Ethnic Affairs 1992, known as Lim's case, said that such detention would be unconstitutional unless approved or reviewable by the courts. Local human rights commentator Father Frank Brennan wrote just last October in an article published in Interface, and I quote, "There are grave doubts about the legality of the detention of those Palestinians and Iraqis who have been rejected and who have made written application to be removed from Australia, but who must wait in indeterminate detention through no fault of their own. Their indeterminate and unreviewable detention is not for an immigration purpose." In Lim's case, the High Court upheld immigration detention, in part because the detainee could exercise the option at any time to leave Australia. Also, at the time of Lim, there was a strict time limit on detention. There is a need for periodic judicial review of post-rejection detention, permitting the release of persons on bail provided they have fulfilled health, security and identity checks, and provided the court is satisfied that any person bailed is likely to be available for a return to detention immediately prior to removal from Australia. End of quote. Why then does the government not support this reasonable ruling? The 1998 White Paper set out the criteria by which Immigration Act powers of detention were exercised and confirmed that the starting point in all cases was the presumption in favour of granting temporary admission or release. Since Lim's case, Mr Deputy Speaker, any case involving indefinite detention or detention beyond the period that is reasonably necessary for processing or deportation may be unlawful. This is because a question may be raised as to whether the detention is reasonably capable of being seen as necessary for the purposes of immigration processing or deportation or removal. It may also raise a question as to whether the detention should be characterised as punitive. As I said, the government tells us that such open-ended detention is not punitive. Yet High Court judges Brennan, Dean and Dawson found it to be so back in 1992. In Lim's case, they found that, and I quote, "If the detention which those sections require and authorise is not so limited, that is, reasonably capable of being seen as necessary for the purposes of deportation or necessary to enable an application for an entry permit to be made and considered, the authority which they purportedly confer upon the executive cannot properly be seen as an incident of the executive powers to exclude, admit and deport an alien. In that event, they will be of a punitive nature and contravene Chapter 3's insistence that the judicial power of the Commonwealth be vested exclusively in the courts." End of quote. Simply put, the government's action is punitive and the court therefore has a role to play in dealing with this matter. The issues in Lim's case arguably reflect the broader proposition that Australian law does not support arbitrary detention of asylum seekers. This proposition has also been extensively explored in the context of international law. Legal debate aside, Mr Deputy Speaker, The Greens principally object to this legislation on the basis that it is yet another example of this government's sheer immorality on this issue. Its willingness to detain people indefinitely for the apparent crime of seeking asylum in this country defies explanation or understanding. The Greens condemn the government for this bill and strongly oppose it as a result of that. Amnesty International is also one of the many voices in the community which is part of a chorus of opposition to the government's current detention regime. Amnesty is opposed on the basis that this regime is, and I quote, arbitrary, a form of state-controlled custody without charge, trial or independent review of whether detention is necessary in the individual case, appropriate and otherwise meets international human rights standards. End of quote. Amnesty International opposes Australia's punitive measures to deter unwanted asylum seekers by treating others harshly, even though they committed no crime. Specifically, the organisation objects to the use of detention of unspecified and potentially unlimited duration without judicial review. They object to the automatic detention of children and to detention in conditions which may be considered degrading or inhumane. The recently released Chill Out report, entitled The Heart of the Nation's Existence, gives numerous examples of where the treatment of children in Australian detention centres is degrading, is humane, and previous speakers in this debate have referred to that. Such violations of human rights cannot be justified as a method of deterring potential asylum seekers. Amnesty International is concerned about a detention regime which takes no account of the effect of prolonged detention on the mental illness and well-being of detainees. The psychological impact of detention, and particularly indefinite detention, has been well documented. The legality of mandatory detention under international law has also been widely canvassed. It has been argued that mandatory detention is contrary to the prohibition on unnecessarily restricting the movement of and or penalising bona fide asylum seekers in Article 31 of the Convention relating to the status of refugees. International human rights instruments refer to detention as a deprivation of liberty. They clearly distinguish it from incarceration resulting from criminal charges or sentencing. Under its guidelines on the detention of asylum seekers, UNHCR, the United Nations Refugee Agency, considers detention as, and I quote, confinement within a narrowly bounded or restricted location, including closed camps, detention facilities or airport zones, where freedom of movement is substantially curtailed and where the only opportunity to leave this limited area is to leave the territory. End of quote. The guidelines state that in the view of the UNHCR, the detention of asylum seekers is inherently undesirable, and that, as a general principle, asylum seekers should not be detained. The guidelines require that permissible exceptions to the general rule that detention should normally be avoided must be prescribed by law, and that such exceptional detention should be for a minimal period only. The guidelines also explicitly declare that detention, as part of a policy to deter further asylum seekers, is contrary to the norms of refugee law. In the Al-Masri decision, in the federal court, the full court commented that we are therefore fortified in our conclusion that 1961A should be read subject to an implied limitation by reference to the principle that, as far as its language permits, a statute should be read in conformity with Australia's treaty obligations. To read section 196 comfortably under Article 9(1) of the International Covenant on Civil and Political Rights, it would be necessary to read it as subject, at the very least, to an implied limitation that the period of mandatory detention does not extend to a time when there is no real likelihood or prospect in the reasonably foreseeable future of a detained person being removed and thus released from detention. As was noted by Kerry O'Brien on the 7:30 report on the 27th of May, the federal government's tough strategy to stop asylum seekers arriving on the Australian coastline appears to have worked. However, the humanitarian cost is real and tragic. 7:30 report went on to document the suicide of an Afghan refugee on a temporary protection visa. In his suicide note, Habib Vahidi said he feared Australian authorities and that he believed he would never see his family again. There are other examples of where this inhumane policy has had adverse effect upon the individual refugees, whether they be man, woman or child. It appears that the government has learned nothing from these outcries by local and overseas human rights groups and that this bill is just another example of the government's tough stance on asylum seekers. The Australian Greens ask this government and the Minister for Immigration, at what cost must our borders be protected from asylum seekers? Will the government stop at nothing to prevent asylum seekers from enjoying a limited amount of freedom, however briefly, in this nation? Apparently not. We've seen only too well in the last week or so the limits to which the Minister will go to defend and enhance the current detention regime, especially in regards to the children in detention. In summary, Mr Deputy Speaker, this is a shameful piece of legislation. The Australian Greens condemn this bill, and we condemn this government for its continuing inhumane treatment of asylum seekers.